the development of a sense of ownership across countries. And that could be the contribution of UNICRI, in a sense that we will be prepared to engage experts since the very beginning of the project in the design and implementation of our projects, because it's important that our products will be tailored to country needs and also the legal framework. And in more general sense, I like to say that UNICRI has a bottom-up approach, in a sense that we don't want to deliver products which are being just designed in our headquarters. It's more important that we produce products which are really targeted to the needs of member states and national experts. And so that's part of my answer.
Anyone else on the training of journalists? So, dear?
Thank you. Well, it's not only journalists, it's also internationals. This is an important question that was asked first. Who is going to monitor what's happening? OSCE has been doing just that for years now and will continue to do as long as its presences, its missions remain in the countries concerned. But there is also, of course, the question what happens afterwards. Who will do that work afterwards? And here the media and civil society can play an important role. And I would assume that part of the exit strategy for the OSCE missions in the region should be to train the media and to work with the civil society in order to continue this essential work. Let me also add that since all the countries concerned have a very strong European perspective of the membership of the EU, one of the most important negotiating chapters for the accession to the European Union is about the rule of law. So this issue will not go away, it will stay there. And my final point is, the fact is that after a couple of more trials, this court in The Hague will no longer be there. And it will have to be national courts, national prosecutors, national defense lawyers and investigators that will have to continue to do this work, I guess, for decades to come. Thank you.
The question from the second question from the gentleman from the International Crisis Group, Serge Bremetz, you may have something to say about it. Why not, in the time you've got left, use young lawyers, young local lawyers in your teams? That was certainly done at Sierra Leone. And attach them to the legal office and to the prosecuting and indeed defense teams.
Yeah. That's exactly what we are doing since last year with one of those projects financed by the European Commission, where we have not only those liaison prosecutors who have access to important parts of the databases, but we have also more than 10 young lawyers from the region since last summer, coming every time for 6 month periods, and they are integrated into the trial teams and working on the cases. And I really would like to say that those experiences are very positive and very encouraging, because I had several meetings also with the senior trial attorneys to see what is the level of knowledge, of experience of those young lawyers. And the answer I'm mainly receiving is that they're absolutely up to speed and have the right level to be helpful. On the journalists, I have to say that we have also on a regular basis journalism students or students in journalism from the region visiting the tribunal. I had several times meetings with young future journalists from the region in trying to explain what we are doing.
Right. The next point was a very important and difficult one, and it probably deserves a later session for exploration. But President Robinson, a word on this very great problem we face. It's faced in Sierra Leone and all around, on declassifying material. You're all for transparency, but some of those witness statements could put witnesses at risk if disclosed too early. There may be material relating to sources which would be uncomfortable for the source if released early. How are you going to go about ensuring your duty to those who've helped the tribunal in confidence?
This raises the question of reconciling the public policy interest in making public the documents and records of our trials, on the one hand, with the interests of those victims and witnesses who were given special protection by trial chambers. It's a question that I am now in the process of considering. I'm obliged to consider it because the Secretary General has mandated that it be given consideration. We are still looking at it, the judges and myself, and we have not yet come to a clear decision as to how this will come out. But we are very sensitive to the need to strike that balance. The judges are very, very clear in their own minds that declassification should not take place without the consent of those victims and witnesses whose testimony is involved. The judges attach paramount importance to the question of consent and to ensuring that all steps are taken to ensure that consent is obtained, and where it is not practicable to obtain it, then other mechanisms may be put in place. But I can't give you a clear answer. I can just say that we are giving it very, very careful consideration, and we have to strike the balance between the two sets of interests that I identified.
It's an ethical issue that you certainly will have to look at closely. What about the ownership question? Do you have any view on that? I guess the ownership technically is of the materials is in the United Nations.
Yes, it is technically, by that you mean legally, yes, in the United Nations, but in a more practical sense, the archives, I think, may be seen as material in which victim states have a great interest and have a very strong moral claim. But at the technical level, it's the material of the United Nations. Can I just mention one matter that was raised? It's in relation to the person who asked about reparations, because I attach importance to it, even in this time of recession. And I have now on 3 occasions raised it with the Security Council and the General Assembly. I have not had any favorable reply. That may be due, I hope, more to the economic situation in which we find ourselves than to any principled objection to the question of reparations, which is grounded in international law.
Finally, the last questioner had a question for you, John Hocking, as well as for me. Would you like to answer first?
Thanks very much, Jeffrey. In fact, I'll touch on a number of issues, but I'll do it quickly because I know we're short of time. Firstly, on the media strategy and the outreach program, it was in fact the Tribunal very early on, back in the early 1990s, that realised just how important outreach is if we are going to be an effective institution. And we've never received, it's never been part of the regular budget of the United Nations, and it was in fact our president, former president, MacDonald, who I'm very pleased to see sitting in the front row here and who will be moderating panel 3 later, who instituted and set up the Tribunal's Tribunal's outreach program. This whole conference is indeed part of that work, and we're very grateful to the EU, the banker, for funding our outreach work to date. Just on the issue of professionals on staff coming from the states of the former Yugoslavia, the Tribunal is a United Nations institution. It does not discriminate on the basis of nationality, and in fact, I'm sorry, I don't know, it must be some time since you were at the Tribunal, because it's simply not the case. We have people from from the states of the former Yugoslavia throughout the tribunal, from the highest P level, from P5 downwards. We have people who work for the judges as legal advisors. We have people in the registry, and of course people in the prosecution. In all areas of the tribunal, there are people on, who come from the former Yugoslavia. The issue of archiving and ownership, I fully appreciate that the Security Council is currently in considering the structure of the residual mechanism, will need to take a decision on the final location of the archives of the tribunal. Of course, it's an important issue, but I think equally, if perhaps not more important, is the issue of access. And location of the archives may not necessarily equate to ensuring that everybody, that there is as broader access to the archives as we can have. And I think that's a very important issue, that we look at access to the archives. Finally, the gentleman from Banja Luka, I remember very well, we had a very vibrant discussion at the launch of the website in Banja Luka. My very efficient staff, we'd call this, it's almost like the Bush Telegraph in Australia, have said to me that, passed me a note that in fact we didn't receive this, but if you'd like to meet up with one of us during the break, we can talk to you about your concerns for the website. The new website, I should say, has received very strong support, a lot of compliments throughout it's been received, and it's a very important part of the tribunal reaching out to the communities in the former Yugoslavia. Thanks.
Thank you, John, and thank you, everyone. I'm sorry, I know there are others who have comments, but you'll have an opportunity to make those comments in later sessions today and tomorrow. We've got to wind up. Let me just assure the last gentleman who spoke that I have nothing to do with the ICTY, and I made my comments really in 1993, picking up those most obvious examples of the feeling of helplessness that we had when watching CNN. I've called for Tudjman's indictment long before he died. But it is interesting that Victor's justice, which was always the allegation against Nuremberg and against the Tokyo tribunals, is coming to mean something else. It's coming to mean justice on victors as well as on losers, and the ICTY may be paving the way eventually for justice on the victims of future Gazas and even future Iraqs. So thank you very much. Thank you to our panel.